I already know what you're thinking. You're thinking, not another James Freeman video, and I agree with you. James Freeman videos are terrible, and they should be stopped. However, I wanted to talk about this one because there is a legal aspect that we can talk about. The video is called Trying to be Served Threats from a Court in Arizona. And it is basically James Freeman misunderstanding not only the law, but philosophy. So let's start with the law. This is the Penal Code of Texas. Threats, I'm going to assume he's talking about, if he is actually talking about something legal, which I doubt because he blurs all the lines of everything, as a good sovereign citizen should. But this is 22.01 assault, subsection A, subsection 2, or subsection A, part 2. I don't actually know how you would refer to that, but it's 22.01 A2, intentionally or knowingly threatens another with imminent bodily injury, including the person's spouse. So imminent means it is about to happen. And in Olivas v. State by the Texas Court of Criminal Appeals, which is the criminal version of the Texas Supreme Court, they said that the crucial inquiry remains whether the assailant acted in such a manner as would, under the circumstances, portend an immediate threat of danger to a person of reasonable sensibility. And when you combine that with the imminent bodily injury, what you have is you're about to be hurt. Doesn't matter what you do, you're about to be hurt. Someone points a gun at you and says, I'm going to shoot you. You're about to be hurt. If someone points a gun at you and says, get off my property or I'll shoot you. Well, there's a question, isn't there? You can get off the property or he'll shoot you. Is he breaking the law by doing that? Maybe. It just depends on the state. It depends on the local state statutes, etc. Different states have different case law. In Texas, you could probably point a gun at someone on your property and say, get off my property or I'll shoot you. And that would not be assault by threat. So we're going to watch this. First, we're going to watch it. We're going to see if there is an assault by threat. We're going to see if there's a legal threat against Mr. Freeman. And then after we watch it and we see that there is not, in fact, a legal threat against Mr. Freeman, then we'll turn to a more philosophical endeavor and poke philosophical holes in Mr. Freeman's position. So I believe we're at 2 times speed. I apologize in advance. This is fair use. Please don't strike me.
How you doing? Is that a law? What? I can't. I was told that I could record here by DHS. DHS told me I could. I'll go check with him.
The first stupid thing he's doing is saying that, oh, I was told I could record here by DHS. Space occupied by a tenant agency, so you may take photographs of space occupied by a tenant agency only with the permission of the occupying agency concerned, or only with written or permission by authorized official from the occupying agency concerned. So the DHS can't give him permission to videotape in tenant space. So that's dumb. And then also you may note really quickly that federal court orders or rules prohibiting it also would prevent him from filming. Not to mention security regulations, rules, or orders or directives. So he's not obviously caring what the law is. He's playing stupid games in a desperate attempt to win stupid prizes.
I'm not. It's pointed down.
They are both aggressively approaching me now, he says in exposition, not showing them aggressively approaching him. You will notice that he does not get touched at all, ever, in this encounter. You will notice that he films the entire time in this encounter. You will notice that none of them draw their firearms at all in this encounter. And yet here I am expected to believe that there is some ominous threatening force directing James out of the area, or imminent danger, imminent harm will come to him. He says, I can tell it's going to get bad quick. Oh, he's psychic. Everybody applaud for James, the psychic sovereign citizen. But if I turn it off, no one will ever know. No one will ever know that you weren't touched. No one pointed a gun at you. No one put you in handcuffs or touched you or did anything at all to you. It's a good thing you filmed, huh? Boy. Crisis averted. So if I point it down and push the button to the elevator, or so I pointed down and pushed the button to the elevator to get out. But you notice they weren't saying point it down. They were saying turn it off. You are still violating 41 CFR 102-74.420. You have uploaded a video showing you doing it. I believe I'm supposed to say you are uninformed or misinformed at this point. I can't say that your actions are stupid or retarded because that would be bad. I have to say you're uninformed or misinformed. But I don't think you're uninformed or misinformed. I think you're deliberately misreading, and you're deliberately misquoting, and you're deliberately pushing. But that's me being psychic, and I should admonish myself right now for me being psychic. But that is what I think you're doing. I could be wrong.
Turn it off. Are you here to see somebody?
Yeah, I am. Mike De La Garza.
Turn it off.
I have to. Okay, I'll have him come outside then and meet me outside.
You go ahead and leave. You can't
Yeah.
go live.
I know the trolls will say they didn't threaten you, and it's precisely because they didn't threaten you. What did they threaten you with, James? Oh, well, they didn't actually say it. It was their intimidating stance. Yeah. Okay. So go ahead and tell me in the comments what you think they were going to do other than using violence to make me shut off the camera and or leave. Well, James, they haven't used violence yet. So let's just finish the video and see what they do.
We told that you were coming up and what to do.
Okay.
There'll be someone to come out for you.
Yeah, I'll come out.
Turn that off.
I'll have him come outside.
Yeah, that's the only.
Tell him I'll be out front. He can bring it to me out there. Well, you're the one kicking me out, threatening violence against me.
Oh, gosh, golly, Mr. Freeman, they got you to leave without threatening violence, without touching you, without assaulting you. Everything you claimed would happen didn't happen. They never threatened you. Period. Done. They didn't do it. Now, as for your saying government is literally ruled by force, it is. Government is literally the rule of force by the majority. If the majority ceases to believe in the efficacy or legitimacy of government, the majority will rise up against the government and take by force the authority, the power, the enforcement away from the government and install a new government. I never said they didn't, James. If you don't eat your liver and onions, when you're a child, your mother will give you the choice of either eating your liver and onions or getting a spanking and sent to your room to go to bed hungry for the night. Life authority is based on conditions. You can either do this or this will happen to you. And it has to be that way, James. If you stop for even a moment to think about it, it has to be that way. If somebody walks up to you and takes your stuff, let's just say that let's just pretend for a moment that somebody walks up to you and steals your wallet. And you say, please, may I have that back? They say, no. Now what? Oh, you call the police? Great. All right. So the police show up and the police say, please give James back his wallet. And they say no. Now what? If there is no force or threat of force, then there is no enforcement of laws. Notice the word enforce laws. Force is a portion of that. If the police don't enforce the law, then people won't follow the law. If I wasn't going to be subject to getting a speeding ticket, I would not follow the speed limit. I would cut in line. I would do all sorts of things that would annoy my fellow citizens. And you would too. And you do it anyway, despite laws being enforced. But I guess that's the difference between you and me. So yes, government is literally rule by force. Now there are limits on the government's rule by force. The Fourth Amendment limits the force that the government is allowed to use to arrest you to reasonable force. The Eighth Amendment limits the ability of the government to inflict cruel and unusual punishment against you. So the intellectual giants in here talking about people being put in cages and beaten and raped. Well, that's against the law. So if that does happen, there can be criminal actions against the police officers involved. There can be employment actions against the police officers involved. They could be fired or suspended or whatever. And there could be civil actions against the police officers involved. But that's if they act unreasonable in terms of the Fourth Amendment, not what you subjectively think is reasonable, James, because you are not the average person. So there is no threat. There was no threat. There is an underlying basic assumption in society that if you don't conform to the rules of society, then you will be punished. And if you don't agree to the punishment, then force will be used against you to put you in a position where the actual punishment can be enforced against you. So you may notice that we don't have like hands getting chopped off or tongues getting cut out or ears getting gouged. What we have in our country is incarceration. You get put into a prison or a jail. You can call it a cage if that makes you feel better. But that is what society has deemed appropriate. If you've done something bad enough and you're in a state that for whatever reason allows it, and I am against it, but if you are in a state that allows it, theoretically the death penalty could use against you. That's it. Incarceration, death penalty, and monetary sanctions. That is it. The sum total of the allowable penalty, I should say, penalty for violating the law. That is what they could enforce against you, James. Now, if they had to, if you were obstinate, if you refused to comply with their lawful orders, and they were lawful orders, then they would be justified in using force against you. Because if they could not use force to enforce the law, then people like you would just simply break it. You can differ, reasonable minds can differ about whether or not it is a good law or a justified law or an appropriate law. Reasonable minds can differ about that, but reality is it is a law. And the police can enforce laws. And call me crazy here. Just, I may be way out of the pale, beyond the pale on this, but I'm going to guess that a federal court will find that a federal court's order denying the right to film in a federal courthouse, I'm going to guess that that federal court will find that law to be not in violation of the First Amendment. I know, you're skeptical, but I'm just betting that the court's not going to find its own order to be in violation of the First Amendment. And since we already know that Estes v. Texas, the Supreme Court's already said that courts can do this, that probably the Supreme Court's going to be okay with lower courts enforcing that order. Anyway, I've rambled enough about that. I want to thank whoever decided to flag my video reading comments 5/27/18. Didn't work because, yeah. Anyway, Mr. James Freeman, if you are still watching, this is the phone number to your attorney, 214-653-3550. I would suggest calling your attorney. Finally, probably finally, Mr. Troy Cates, when he's not affecting a silly style with his text, I think he's trying to sound uneducated. Holy dookie, with all that, with all that cow dung on the side. Anyway, when he's not doing that, he seems to be actually a pretty intelligent fella. He pointed out Rothbury v. Gillespie County, Texas. It is a Supreme Court decision, 554 U.S. 191. This was interesting for a couple reasons. He was bringing it up in that Mr. Freeman may have been denied counsel in violation of Rothbury v. Gillespie County. I am somewhat skeptical of that, not because I am against Mr. Freeman, but I would wonder if the attorney, Mr. Woodruff, was notified if the phone numbers, plural, and email address and or physical address that was given at the time of Mr. Freeman's arraignment were valid one way or the other, in part or in total. If one or more of them were valid, I think the court would question whether or not Mr. Freeman had actually attempted to contact his attorney. There is a good question on it, so thank you, Mr. Cates, for bringing it up, and thank you for dropping the affected accent. I really do appreciate that. I love a shtick. I love a good shtick, but if I can't understand what you're trying to get at, it really makes it hard for me to respond intelligently to what you're saying. So again, it was a very good opinion, and it may be applicable. Mr. Freeman, you probably want to get an attorney to look at it. But one thing that I did find interesting was they do go over the 1517 hearing, and it says that there is the magistrate judge does determine probable cause for the arrest at the initial hearing. So, yeah. The original or initial arraignment, I think they called it. So, so there was a probable cause determination by the magistrate judge, or at least we are assuming it was a probable cause determination by the magistrate judge. If there wasn't, obviously that there could be some wiggle room to claim error. Other than that, oh yeah, let's see. I think I want to do James Springer, and I want to do the arraignment packet. One other thing that was interesting, I say interesting very loosely. Somebody had a a huge issue with me saying that Mr. Freeman filled this out, saying that yes, he did want an appointed lawyer, and that he indicated with these, which I assume are zeros, that his total monthly income was zero and the total value of his assets was zero. This would be what he is indicating. This is not, I am not claiming that he had no assets, and this is what he's indicating, though. It is based on these that this is Amber Givens Davis. This is the judge, because the magistrate doesn't make this determination. On this date appeared James Allen Springer, hereinafter referred to as defendant, who makes his initial appearance in connection, blah, blah, blah. And page 2. Here we go. It appearing that the defendant has executed a sworn statement certifying that she is without means to employ counsel and requesting appointment of counsel, the court finds that the defendant is indigent and hereby appoints the attorney David Woodruff. Now, somebody has made a huge issue about these not being zeros and that it wouldn't hold up in court that these were zeros. And they also took huge issue. They believed that I was saying that Mr. Freeman was indigent. I don't believe I said that. And if I did give you that, if I did make it seem that I was saying that, I want to back away from that. I'm saying that he claimed to have zero income and zero assets. He may have had a car, but he didn't claim it. He may have had a paycheck. He didn't claim it. That looks like a zero. That looks like a zero. And a judge accepted that sworn statement as fact. This is a judge. This is indigent appointment, public defender. Now, was this transmitted to people? It does appear that there are evidences of it being faxed in some fashion. I could be wrong. I probably am. There's that. I think that's when it was transmitted. It was on the one page. But I'm not entirely sure. This may be fax information. I don't know exactly if or how the lawyer was contacted, and if or how Mr. Freeman was notified of his lawyer appointment. So I don't know a lot of things about this. I am not, like I said, I'm not licensed to practice in Texas. I'm just going off what I can see and read. So take that for what you will. But a judge did look at it and say that it appears, because of the sworn statement certifying he or she is without means to employ counsel, the court finds the defendant is indigent and hereby appoints the attorney. So a court found that this was a zero and this was a zero. So thanks for playing, Sleeping Beauty, but you lose. Hard. Again. Thanks for watching. Have a great day.